Hello, my name is Steve Murdoch, and I'm a member of the Oklahoma Association of Municipal Attorneys. The OMA for short. One of the missions of the OMA is to provide those across the state of Oklahoma that are practicing in municipal law with resources to assist them in providing advice to the cities and towns they represent. OAMA has established a program that provides such information accessible through the OMA website, which is www.okmunicipalattorneys.org. This segment is an introduction into zoning and land use powers that are available to cities and towns in Oklahoma as a tool to assist in orderly town development that protects property values of its citizens. And let me just add, I've been practicing municipal law for a long time, and one of the most enjoyable areas of my practice has been planning and zoning. And so get into it. I think you'll like it. So let me give you some background in zoning in the United States. The practice of zoning was reviewed by the United States Supreme Court for the first time in the Village of Euclid, Ohio versus Amber Realty Company. Amber Realty Company owned 68 acres in Euclid, a suburb of Cleveland, Ohio. In 1922, the city of Euclid adopted a comprehensive zoning plan via ordinance for regulating and restricting the location of trades and industries, apartment homes, two-family homes, single-family homes, and the size and height of buildings. Amber Realty sued on the grounds that the comprehensive zoning ordinance denied Amber Realty due process of law and equal protection under the law according to the 14th Amendment of the Constitution of the United States. They asked the Supreme Court to prevent the city of Euclid from enforcing the ordinance. The court, in reviewing the case, provided the following history. Building zone laws are of modern origin. They began in this country about 25 years ago, and until recent years, urban life was comparatively simple. But with a great increase in concentration of populations, problems have developed and constantly are developing, which require and will continue to require additional restrictions in respect of the use and occupation of private lands in urban communities. Regulations, the wisdom, necessity, and validity of which, as applied to existing conditions, are so apparent that they are now uniformly sustained a century ago, or even half a century ago, probably would have been rejected as arbitrary and oppressive. Remember those words, arbitrary and oppressive. According to the court, laws such as this one must find their justification in some aspect of the police power asserted for the public welfare. And even though Amber Realty alleged that the value of their property fell from $10,000 an acre to $2,500 an acre as a result of the zoning designation imposed on the lot by the comprehensive plan, the court determined that the ordinance was a valid exercise of the city of Euclid's authority. With this decision in Euclid, the United States Supreme Court opened the door to the proliferation of zoning laws. The cases that followed have mirrored the analysis used by the court in Euclid. Modern zoning laws seek to accomplish the following. Generally, zoning ordinances may be and are designed to guide the future growth of a city. A basic purpose of zoning should be the solution of problems of the present and so far as they can reasonably be anticipated of the future. In this respect, it must be coordinated with city planning as a whole. Zoning seeks to stabilize and protect, not to destroy. It seeks to safeguard the future and also to repair mistakes of the past. And I'm citing Quillen on municipal corporations. You know, zoning of urban land has its main effect upon the rights of inhabitants in a municipality and is therefore a matter of local or municipal rather than of statewide concern. Keep thinking about that. The economic and social benefits of zoning in crowded modern cities is readily apparent. Similar needs for comprehensive zoning in smaller cities are obvious as well. Zoning is essential to the public health, safety, and welfare. Moreover, it is economically desirable and necessary since it results in the most appropriate and economic use of land within the municipal area. You know, but obviously all parts of a city are not and cannot be alike. Different functions are performed in several parts of the community, and consequently different regulations and restrictions and prohibitions are required to serve the needs and conveniences of the several sections. There is an active insistence upon the establishment of residential districts from which annoying occupation and unsightly or undesirable buildings are excluded. Property owners in a residential area who desire to preserve their neighborhood in an unchanged condition must enact appropriate zoning ordinances or be protected by building regulations. Otherwise, any citizen may exercise his or her constitutional right by purchasing real estate in the area and using it for any lawful purposes. Some examples of typical laws and regulations are fixing the height of buildings within reasonable limits, the character of materials and methods of construction, and the adjoining areas that must be left open in order to minimize the danger of fire or collapse. You know, the evils of overcrowding and the like, and excluding from residential sections offensive trades and industries and structures likely to create nuisances are also important. Generally, reasonable zoning, especially when it is comprehensive, is constitutional and valid as a proper exercise of the police power. In other words, a zoning ordinance does not violate due process when it bears some reasonable relation to the legitimate objectives of the police power. The courts generally uphold fair and reasonable comprehensive zoning laws, but take a more active role in reviewing these laws to ensure that they are in fact fair and reasonable. The courts will also determine whether a facially valid zoning ordinance has been applied in an unconstitutional manner by determining whether the zoning decision applying the ordinance is arbitrary, there's that word again, or whether the ordinance has been applied with a discriminatory intent or purpose. Generally, whether or not a zoning ordinance is valid and constitutional will depend upon a reasonably balancing of public interest in zoning as against opposing private interests in property. Let's take a look at some Oklahoma statutes on zoning. In adopting such ordinances, municipalities are frequently guided by state statutes that grant authority to municipal legislatures to zone. Most commonly, these statutes authorize municipal legislative bodies to zone for the purpose of promoting the health, safety, morals, or the general welfare of the community. In Oklahoma, Title 11 of the state statute provides, for the purpose of promoting health, safety, morals, the general welfare of the community, a municipal governing body may regulate and restrict the height, number of stories, and size of buildings and other structures, the percentage of lot that may be occupied, the size of yards, courts, and other open spaces, the density of population, and the location and use of buildings, structures, and land for trade, industry, residence, or other purposes. In addition, municipal regulations as to buildings, structures, and land shall be made in accordance with a comprehensive plan. 11 OS, Section 43-102. The fundamental concept that zoning must be in accordance with a comprehensive plan originated from the Standard Zone Enabling Act issued by the United States Department of Commerce in 1922. Most state enabling acts are commonly patterned after this act and contain, in accordance with a comprehensive plan requirement, this requirement developed to ensure that local governments act rationally rather than arbitrarily in exercising their delegated zoning authority. In Oklahoma, comprehensive plans must be designed to accomplish any of the following objectives. Number 1, to lessen congestion in the streets. Number 2, to secure safety from fire, panic, and other dangers. Number 3, to promote health and the general welfare, including the peace and quality of life of the district. Number 4, to provide adequate light and air. Number 5, to prevent the overcrowding of land. 6, to promote historical preservation. 7, to avoid undue concentration of population. Or Number 8, facilitate the adequate provision of transportation, water, sewerage, schools, parks, and other public requirements. The regulations must also be made with reasonable consideration, among other things, as to the character of the district and its peculiar suitability for particular uses, and with a view to conserving the value of buildings and encouraging the most appropriate use of land throughout the municipality. Municipalities have the authority under Title 11 to provide the manner in which regulations, restrictions, and district boundaries shall be determined, established, and enforced, and amended, supplemented, or changed. Once a municipality has adopted zoning regulations, the property within the applicable zoning district must be developed or built in accordance with the regulations attached to the zoning district in which the property is located. Amendments to the zoning regulation can be made after the appropriate notice and an opportunity to be heard. Let's take a look at some required boards. First, we have the Planning Commission. The municipal governing body shall appoint a commission to be known as the Zoning Commission to recommend the boundaries of the various original districts, to recommend appropriate regulations to be enforced therein. The Planning Commission shall prepare from time to time plans for the betterment of the municipality as a place of residence or for business. Then there's the Board of Adjustment. When a municipality is exercising zoning powers as conferred by the state law, the governing body of the municipality shall provide by ordinance for the appointment of a Board of Adjustment. The Board of Adjustment shall consist of 5 members, each to be appointed for a term of 3 years and removable for cause by the governing body upon written charges and after public hearings. Vacancies shall be filed for the unexpired term of any member whose term becomes vacant. The Board of Adjustment shall have powers to hear and decide appeals of a determination by an administrative official in the enforcement of any zoning ordinance, hear and decide special exceptions to the zoning ordinance, authorize in specific cases a variance from zoning due to unnecessary hardship, and hear and decide oil and or gas applications or appeals. They also can look at decisions or exceptions and or variances that may be appealed to the district court. Notice in public hearings, because zonings of property implicates valuable property rights attached to both the property to be zoned and the property around that to be rezoned, notice an opportunity to be heard prior to a zoning action is fundamental and essential. Parties and interests and citizens shall have an opportunity to be heard at a public hearing before any district regulation, restriction, or boundary shall become effective. Notice of the public hearing shall be published in a newspaper of general circulation at least 15 days in advance of the public hearing. The notice shall contain the date, time, and place of hearing and shall include a map of the area to be affected, which indicates street names or numbers, streams, or other significant landmarks in the area. In addition to publication notice, a notice must be given 20 days in advance of the public hearing by mailing written notice to the owners of the lots included in the proposed change and the owners of lots within a 300-foot radius of the entire exterior boundaries of the territory included in the proposed change. The mailed notice shall contain legal description and street address or approximate location, present zoning and zoning change requested, the date and time and place of the hearing. The notice may also be given by posting notice on the affected property at least 20 days before the date of the hearing. In addition to regular notice provisions, if the zoning change request permits the use of treatment facilities, multiple family facilities, transitional living facilities, halfway houses, or any other housing or other facility that may be used for medical or non-medical detoxification as defined by state law, then written notice of the hearing must be mailed 30 days in advance of the hearing to all real property owners within 1/4 of a mile where the area is to be located. If a municipality proposes zoning reclassifications in order to revise its comprehensive plan or official map or to identify areas which require specific land use development due to topography, geography, or other distinguishing features, including but not limited to floodplain, drainage, historic preservation, blighted areas, the governing body may require, in addition to the regular notice requirements, a sign to be posted on designated properties within the area affected by the proposed zoning reclassification. The sign and lettering shall state the date and time and place of the public hearing, who will conduct the hearing, the desired zoning reclassification, the proposed use of the property, and other information necessary to provide adequate and timely public notice. There are also protest rights. Protests against proposed changes shall be filed at least 3 days before the date of the public hearing. If protests are filed by the owners of 20% or more of the area of the lots included in a proposed change, then the proposed change or amendment shall not become effective except by the favorable vote of 3/4 of all members of the municipal governing body. Where there are more than 7 members of the governing body, and by 3/5 favorable vote where there are 7 or less members in the governing body. If protests are filed by the owners with 50% or more of the area of the lots within a 300-foot radius of the exterior boundary of the territory included in the proposed change, then the proposed change or amendment shall not become effective except by the favorable vote of 3/4 of all the members of the municipal governing body, where there are more than 7 members of the governing body, and by 3/5 favorable vote where there are 7 or less members in the governing body. Injunction and appeal. A local municipal authority or any other person affected thereby may bring an action to prevent the unlawful erection, construction, reconstruction, alteration, repair, conversion, maintenance, or use, or to restrain, correct, or abate any violation, or to prevent the unlawful occupancy of the building structure or land, or to prevent any illegal act, conduct, business, or use in or about the premises. Any suit to challenge any action, decision, ruling, or order of the municipal governing body under zoning powers shall be filed with the district court within 30 business days from the action, decision, ruling, or order. Any suit to challenge any action, decision, ruling, or order of the Municipal Planning Commission shall be filed with the district court within 30 business days from the action, decision, ruling, or order. Zoning by municipal government is rooted in the police power to provide for the general health, safety, and welfare of its citizens. It is economically desirable and necessary as it results in the most appropriate and economic use of land within the municipal area. Zoning ordinances may be and are designed to guide the future growth of a city. It protects property rights by restricting the unfettered use of land to the detriment of adjoining properties. Proper and thoughtful zoning requires the adoption of a comprehensive plan. The comprehensive plan will help facilitate provision of transportation, water, sewerage, schools, parks, and other public requirements. A comprehensive plan providing long-term planning will help lessen congestion in the streets, prevent the overcrowding of land, promote historical preservation, help avoid undue concentration of population, and provide quality of life in designated districts. If your city or town does not already have zoning regulations governing property in its city limits, then the process to accomplish this regulatory structure to avail your city or town of the zoning powers conferred by the Oklahoma statute is through the establishment of a zoning commission as provided in 11 OS section 109. The zoning commission will make a recommendation of boundaries and regulations following a public hearing. The governing body will then consider the recommendation of the zoning commission, hold public hearings, and then can take action establishing zoning and regulation applicable to the property within its city limits. Future segments on municipal zoning and planning will cover functions of a planning commission, the Board of Adjustment, specific use permits, and use of planned unit developments. The Oklahoma Association of Municipal Attorneys exists to provide support to attorneys practicing municipal law for the several hundred cities and towns across the state of Oklahoma. My name is Steve Murdoch, and I practice municipal law since 1986. If you have municipal law questions and OAMA can help you, please reach out to any of our member practicing municipal attorneys or through the Oklahoma Municipal League or other municipal practice resources such as the Oklahoma Municipal Assurance Group or the Oklahoma Municipal Management Services. Their contact information can be found at the OAMA website, www.oklahomamunicipalattorney.org. Thank you.